Hello again, Mr. Casper.
Hello, Your Honor. I want to thank you again for working with me on this.
Well, you lucked out. This was a day where there was some give in it, so happy to accommodate. Hopefully you're pleased that you're moving from apartment to apartment.
Apartment to house. Very pleased. Me and my wife have a little 2-year-old boy, and he needed some more space. So we're very pleased. He's very
hopefully
pleased.
Not too many stairs in the house.
There's probably more than I would have liked, but he seems to like running up and down them or crawling up and down them. So, so far so good. But we've only been here since Saturday, so
The up is good. It's the down that's the danger part.
Exactly. Gates being installed tomorrow. So
good. So Ms. Niles did some homework in between our two calls, and she helped me understand how service works in this role that courts play in the non-judicial foreclosures is a little atypical. It's supervisory, whatever that means. And so
right.
I now understand that the complaint or petition that you filed is not a new civil suit. It's just seeking confirmation, which of course what it says.
Right.
But that means that the 911-4 and some of the service provisions don't apply.
Right.
I just need to be comfortable that defendants did get notice of the hearing today.
Yes, we we mailed out notice of the hearing dates. Yes.
Okay. And is it your understanding that Ms. Herrera still lives at 1871 Windermere, or that's just the only address you've got?
I believe it's the only address. We actually, I think, may have sent her notice. She does not live there. This is actually was a business purpose loan. It was I think she and her entity, the company 1870 Windermere, I think it's a single person or purpose LLC, but I believe this was a rehab loan or a construction loan. So she was actually sent the information at her address, which is in Texas.
Okay, so she is a non-resident participant in all this.
Correct.
Or non-participant in all this. Okay. So we've cleared that hurdle. Why don't you do what you think you need to do in terms of the confirmation piece?
Okay, so as you say, you haven't done many of these. We haven't done many of these either. It's sort of obviously not something that's done on most residential mortgages, but something we're approaching here. So, my experience doing these is typically I've kind of just walked through the complaint with the court. Ultimately, as you've already indicated on our prior call, it's really going to come down to the fair market value issue. But as you see in our complaint, the entity 1870 Windermere and Ms. Herrera as a guarantor took out a mortgage from my client or from the predecessor client to presumably rehab the loan. It was a commercial interest-only balloon mortgage. That initial mortgage was in the amount of $1,975,597, $1,975,597 for the property in question. Not surprisingly, or should be evident, they went into default. Ms. Herrera went into default on this mortgage, and in September of last year, September 28th, the property, we noticed the defendant or the borrower, as well as the entity, both at the property address, the registered agent, and as well at her personal address, that she was in default. The loan was being accelerated. Pursuant to statute, we ran beginning in October 9th of 2020, 16th, 23rd, and the 30th, we ran the advertisements in the DeKalb paper, or excuse me, in the proper paper, looking at the wrong thing, the Fulton County Daily Report. Ran the advertisements, and then on November 3rd, it was sold on the front of the courthouse door. The highest bidder, as you see, was for $1 million. As you see, the total that was owed was well over $2 million, 2.117 million. As you see, my client did get an appraisal on the property. As you were aware, and as we discussed, the appraisal on the property showed a value of $1.45 million. As you indicated on our chat, I guess we'll call it, There is a substantial difference between the appraised value and what the purchase price at the sale was. You know, I don't really have any case law or statute that sort of sets in and says, oh, this is a reasonable difference. I mean, obviously, it's not expected to be dollar for dollar the same thing. What I've indicated in prior courts and I indicate here is that due to the nature of this, we don't necessarily have access to the full property. The appraisal is done post-sale. So, we don't necessarily have access to go and appraise it pre-sale and say, all right, well, this is what it's worth. The banks just make sort of a rough estimate, say, hey, this is what we want to start at. We want to, hopefully maybe entice a little bit of bidding into the property. And then this is what our top number will be, where we'll bid up to that amount. And then at that point, we're going to stop and you're going to, someone else wants to outbid us, great. And that bid was a lot closer. It was 1.35 million, which was a lot closer to the appraised value. It just turns out in this case, no one bid.
What was the 1.35? That's what your client was willing to bid up to?
Yes.
Okay.
Yes. That was the number they gave us as sort of what they called their competitive bid. They give us their starting bid, increments that they can increase, we tell the bidder or person bidding to increase, and then that's what they call the competitive bid, which is their top bid of what they're willing to do.
Okay, so if Ms. Herrera had showed up and said, I bid 1.4, you or whoever was there on behalf of DLJ would have needed to get additional approval from DLJ to exceed the 1.4.
Well, they would for the bank itself to exceed that to match the bid. So what I'm saying is a competitive bid. We have John Doe calling the bids. We have somebody, typically it's the same person who's there on behalf of the bank who will say, okay, this is our opening bid. People step in. Ms. Herrera steps in and says, I bid 1.1. We started $1 million. She says 1.1. We have an increment. Let's say it's up by $50,000. We do 1.1. If it gets up to 1.4, if she bids 1.4, that's it. She would.
Oh, your client would walk away. They would stop at 1.35.
I mean, yeah, because of sort of the timing of these things, we're not necessarily, hey, give us an hour, let's go call.
Yeah.
We sort of have our competitive bid, like our client's willing to go up to this point, and if it gets above that, great. They'll take, it'll go from there. Whatever overage they can get, that kind of thing. In this case, there wouldn't be any, any money going to a secondary, a secondary lender or anyone else. There wouldn't have been any.
Okay. So I follow that, but I have two data points that suggest that maybe the true market value was not obtained. Whatever true market value is, I think some economic purist would say, well, it's clearly $1 million. There was an auction, and look what it sold for. I happen to have seen these auctions because they happen on the steps they occur on the steps of the courthouse. I don't know how open and public they really are. I mean, physically they are. A bunch of people with green T-shirts handing out donuts for a lot of it, but in pre-COVID times.
Sure.
But I'm wondering if my role is binary. Either this is what it is and I confirm it, or it's not confirmed. That would be the binary. Or if there's some equitable give and a court reviewing a non-judicial foreclosure can say, hey, they checked all the boxes. Notice was proper, the foreclosure was proper. But I'm going to say that the deficiency is 300 grand less than the math of 2.1 million minus 1 million, because I don't think 1 million was true market value. There's nothing wrong with the auction other than it didn't yield what these other data points say is true market value. And that way it's confirmed, but insofar as your client seeks to recover the deficiency from Ms. Herrera or the LLC, they're recovering a little bit less because they didn't pay true market value for it.
Right.
So what I said hopefully makes sense. I just don't know if it's doable. If that, it's interesting that a judge might think that, but the judge can simply either say, yes, it was good, or no, I'm not confirmed.
No, that completely makes sense. I understand. I have not, as of yet, had a judge sort of go that route. It's been, yeah, this is confirmed, this is not, they've been within 10%, 20%, the ones we've gotten. I just want to make sure clear, the deficiency we're seeking wouldn't be the total. We'd only be able to seek the deficiency between the fair market value, which is the 1.45 million, and the purchase price, the 1 million. We wouldn't be able to seek the full deficiency. It's my understanding, but we were both fairly new to this. Like she owed $2 million plus.
Yeah. And you foreclose, and I guess, so the loan is simply secured by the property. And if the property, forget about, let's say that you sold it, you were able to buy it for 145.
Right.
That's just too bad for the lender, because they're owed 2 million and they're recovering 145 from the sale. They can't.
And I guess what I'm sort of thinking is if it were sold at 1.45, and that's the appraised value, then I think, well.
So if it was sold at 145, my job here is real easy. I confirm it. Like, wow, that's amazing. You sold it for the appraisal. I wonder who this appraiser is. But I mean, let's say the appraisal was 1.4 and it sold for 138. You confirm that. I mean, that's not anything anyone struggles with, assuming proper notice was given, et cetera, which it was. But is your client not still entitled to say to Ms. Herrera, it's great that we sold it for 1.4, but you owe us 2.1. So there's 700 grand that is outstanding.
I think I misspoke. I backed this the wrong way. So the difference is not what we would be seeking the difference between the 2.1 that she owed and the 1.45 that was bid. That's the fair market value, not the bid. So I want to make sure I was clear that we weren't seeking the full million between the two.
And why is that? Why would you not be free to seek the full million?
Because it wasn't fair, because the difference, we can only seek the difference between the fair market value and what she owed.
I agree. I think that's true. So you avoid
because
these
otherwise we could bid $1.
Sales.
Right. We could say, all right, we're going to bid $1. I don't mean to interrupt, but we could say we're going to bid $1. No one shows up for the sale. We bid $1. We get the house and we can sue her for $2 million.
Right. So you can then flip the house for $1.4 million and you're getting another 2 million from her. That's not supposed to happen.
Exactly. So,
but I thought that the way confirmations work is that if a judge blesses the sale, the judge is saying it sold for true market value. And then your client is entitled to the difference between the million and the 2 million because it sold at $1 million. And that's what the one important thing, other than making sure notice was given, that the judge is supposed to do, say, well, wait a minute, there's appraisal at 1.4 and it sold at $1 million. That's not fair market value. So I can't confirm it, because if I were to confirm it, then your client says, all we got was $1 million and you owe us 2 million. So where's that million? And there's a $400,000 windfall. And I want to be clear, I'm not suggesting anything went wrong inappropriately or anything like that. But it doesn't sound like fair market value was achieved, or as they call it, true market value. And so that's why I was asking, because the way you're describing it, there's sort of no point in the confirmation other than making sure notice was provided.
Right.
If your client was acknowledging, hey, because we got an appraisal at 1.4, the only deficiency we could seek from Herrera would be the 700 grand difference. But then there's the 400 extra in there. And so that's all I'm wrestling with, because it's a meaningful piece. It's 35%.
Sure. again, I have not had, we've had, all of my prior ones have been so close that it's just been,
Yeah.
this is fine, you're good to go. So I do believe that it may simply just be a matter, and I haven't seen any case law as I'm sort of reading, as I'm reading what you're saying, that's probably, I haven't seen a case law that's going to benefit my client in the sense that you're able to reset it, any of the numbers unilaterally.
I mean, I obviously can't change. It's sold for what it's sold. And then we've
Right.
got this other data point of the appraisal. And now a third one, which is the competitive bid, max bid, whatever you were calling it. And those three data points, if you look at them, suggest that maybe true market value wasn't obtained. So I guess I'll need to look at the case law. I don't see why it's your client's problem if they show up and they say, well, we're going to start at $1 million and no one else is bidding. I mean, can they not foreclose on this? I mean,
Right.
they should be able to foreclose. They're the holder of this debt. But at the same token, if other parts of the market are saying, hey, this house is more like 1.4, then the auction just wasn't particularly efficient, and that ought not to hurt Herrera and the LLC. So I'm just trying to find an equitable way to work through this, believing that no one did anything wrong. It's just, it's an imperfect marketplace.
Okay. Well, I mean, that all sounds exactly, that sounds sort of how I would describe it. I mean, as you said, the banks aren't there, the bid is kind of what the bid is. They're sometimes maybe hoping to push a market a little bit, alternatively, but in a COVID world, that doesn't seem to be happening quite as not as many third-party bidders as there may have been prior to COVID. So.
Well, why don't we do this, unless there are other things you want to share with me? If you don't mind poking around a little bit in the case law, and I'm going to have Ms. Niles look around as well, just to see, this can't be the first time something like this has happened. And maybe the Court of Appeals has provided a few yardsticks or a rule of thumb that if the court feels like otherwise the proceedings went according to all the rules, it's just a windfall for the lender. So I don't know. This is probably the second or third one I've done in 10 years. So,
I understand.
Why was it non-judicial?
Why did we do it non-judicial? Because it's Georgia's non-judicial allows non-judicial, and non-judicial is much quicker and easier.
Okay. Well, then maybe I should ask it differently. Why don't we see more confirmations? Do you not need a confirmation if it sells?
I think it's a couple things. I mean, you can obviously, attempt to sue on the note. The advantage, and really what is really kind of what the deficiency action is, this is just the confirmation allows us to sort of set a benchmark as to some of the factual questions. It was foreclosed on properly. We legally took possession, or legally took ownership. And the court determined that the foreclosure was done and there was a fair market value.
So if most non-judicial foreclosures extinguish the debt, there's no point. Why would you spend money on confirming it? We got more from this sale than the guy owed. We're done.
I think you see it potentially in more business type loans because they're balloon, they're single payment. They're sort of like, you got this, you got to pay us off in a year.
Yeah,
I do know during the previous recession, the Obama administration had sort of put a hold on some of the taxable liability. It used to be that if you didn't get confirmed, you didn't owe the money, and it sold for less than the property was worth, or that you owed, you pay taxes on that. I know that during 2009 and on, when I started in this sort of general field, there just wasn't a huge appetite to sue individuals to try to recover $75,000, $100,000.
Right.
In the middle of it. I mean, it's just, and they're probably never going to be that sort of appetite. So you're really only going to see these in larger business.
Right. When the gap is as big here, I mean, it's going to be $1 million. It's going to be 700,000. That's a meaningful amount. It's not 32,000 where it just That's
And
the
you're never
risk of
gonna-
lending.
And you're never going to collect it. So
Yeah,
this,
right.
you have a better opportunity. So.
Okay. Well, I'll take it under advisement. If there are cases, you don't need to write a memo. You can just send Ms. Niles, hey, I think these 3 cases are as close as they get to being helpful. We'll look into it as well. Then I'll let you know. If it's going to be confirmed, Ms. Niles is going to ask you to submit a proposed order that has all the magic language in it that will do what you need it to do.
Okay.
All right.
Not a problem. All right. Thank you so much for your time, Your Honor, and I appreciate you working with me this morning.
No problem. Go get that gate installed.